Clerk will ring the bell. For what purpose does Representative Werkheiser rise?
Madam Chair, I would like
Would you like to make a motion?
I would like to make a motion.
State your motion.
I would like to suspend the rules of this body for a resolution to be read for the first time and assigned to committee.
The gentleman has asked the rules be suspended so he can have a bill read and assigned to committee for the first time. Is there objection? The chair, seeing none, it is so moved. Clerk will read the caption.
A number of House resolution by Representative Werkheiser, the 157th, and others creating the House Study Committee on Coal Ash.
Special rules. Clerk will read the captions to a group of privileged resolutions.
Recognizing and commending Councilwoman Felicia A. Moore. Recognizing Reverend Claude D. Porter Sr. Recognizing and commending Travanta D. Burgess. Recognizing and commending the 2015 Child Fatality Review Committee of the Year, Northern Circuit. Recognizing and commending the Cherokee Circuit Child Fatality Review Committee on receiving the 2015 Child Fatality Review Prevention Team Award. Commending the smart, talented second graders of Forest Road Elementary School in Columbus, Georgia, for their astronomy findings. Recognizing and commending the Chatham County Child Fatality Review Committee on receiving the 2014 Child Fatality Review Committee of the Year Award. Recognizing and commending Mr. Randy Muth and Angkor Resource Center Incorporated. Recognizing March 21st, 2016 as Single Parent Day at the Capitol. Commending Prevent Child Abuse Habersham and recognizing April 2016 as Prevent Child Abuse Awareness Month at the State Capitol. Commending the senior members of South Cobb High School's softball team on becoming the winningest class in program history. Recognizing and commending Dr. Walter Anthony Rodney and the Walter Rodney Foundation. Recognizing and commending Maddie King Ansley Jackson. And for other purposes, that completes the reading of the privileged resolutions.
Is there any objection to adopting the privileged resolutions? Chair hears none, and the privileged resolutions are adopted. We're on to the rules calendar. Clerk will read the caption to Senate Bill 367.
Senate Bill 367 by Senator Kennedy, 18th, Miller the 49th, Dugan the 30th, Jones the 25th, Kirk the 13th, and others. Being titled an act to provide for comprehensive reform for offenders entering, proceeding through, and leaving the criminal justice system so as to promote an offender's successful re-entry into society. This bill having been referred to the Committee on Judiciary Non-Civil. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative F. Strachan to present Senate Bill 367.
Well, thank you, Madam Speaker. Ladies and gentlemen of the House, I bring to you today very important legislation for this session. This is the...
Gentlemen will suspend. Continue.
This is the 2016 Criminal Justice Reform Bill. It brings recommendations from the Council on Criminal Justice Reform in comprehensive legislation that resulted from study sessions that took place over the summer and into the fall. I took part in one of those sessions, series of meetings concerning reform that's needed for the first offender statute. And as an overview, some members of this body are probably familiar that the General Assembly enacted the First Offender Act in the 1960s after a policy decision was made that certain individuals charged with offenses with no prior criminal history should have an opportunity for a second chance. And what we've seen over that period of time is that, first of all, the judge is given discretion in the courtroom about when that treatment should apply, that offenders charged with certain offenses or defendants are not eligible for first offender. It's only eligible in certain circumstances. And finally, that if a person completes their sentence and does so without issue that would cause a judge to revoke or take away their first offender treatment, then they receive the benefit of their hard work in that they would not have a conviction on their record. Now, in practice, what's been observed is that there are circumstances where an individual completes their sentence successfully, but the first offender disposition remains on their record because of a failure to file the necessary court documents. We've observed that there are other circumstances where there's a question as to what ultimately happened with a case. If a charge was brought, but maybe the DA decided not to pursue that charge and nothing was filed with the clerk of court. This legislation addresses these areas. But just to finalize the first offender discussion, which is part 6 of the bill, it would add additional offenses for which first offender is not applicable. Currently, first offender is not applicable for serious violent felonies, sexual offenses, and other specific offenses. This legislation would add elder abuse and specifically DUI. Currently, DUI is not eligible, but it isn't included specifically in the code. That would resolve that. I'll note that the legislation passed in the Senate unanimously. Part 1 of the bill, I'll just give a brief overview. Part 1 of the bill establishes and expands accountability courts, specifically in the areas of operating under the influence and family treatment court division. The operating under the influence is to encompass both DUI driving and BUI boating. Part 2 allows for the Department of Corrections and the Department of Juvenile Justice to contract for schooling for juveniles that are in state custody, DJJ custody. Part 3 of the legislation provides procedure for administrative hearings before a juvenile complaint, and that's within the school system, proceedings that would take place prior to a formal complaint being filed in the juvenile court. Part 4 of the legislation adds court-mandated activities relating to sentences that would include programs, treatment, and accountability court activities. These are for This is giving greater discretion and abilities for accountability court judges that are making determinations about what a person who's serving in those accountability courts might be able to do. Specifically, allowing driving so that a person can complete the conditions of their sentence and do what's required so that they can be back on track to being a productive member of society. Part 5 transfers or allows for the Department of Community Supervision to replace the Governor's Office of Transition and Support and Reentry. Since this body and the General Assembly created the Department of Community Service last session, this is part of the transition to this new department. I previously addressed Part 6 about the first offender treatment, which is a very important part of the legislation that also would, as I mentioned, would require that prosecutors file an administrative dismissal if a determination is made as to the disposition of a warrant prior to accusation or indictment. Such decision would be filed with the clerk rather than the charge just hanging out there. Additionally, with record restriction, this would allow for automatic record restriction upon the completion of a first offender sentence, or to give discretion to the court to make a determination about whether record restriction is appropriate while the first offender is serving his or her sentence. The legislation would also give automatic restriction for accountability court sentences upon completion. As to Part 7 of the bill, this would include an additional regulation that a probationer's simple failure to pay a fine timely for a misdemeanor sentence would not allow for a probation warrant to lock that individual up without first giving an opportunity for there to be a hearing to take place. And that was an important component of the recommendations made by the Criminal Justice Reform Council. Part 8 is miscellaneous cross-references. Part 9 would provide for parole eligibility for individuals who have been charged with nonviolent drug offenses. Last session, we passed legislation that would allow for such parole consideration, but it was only for certain offenses, and I believe 16631, not for the lesser offenses in 16630, the possession offenses. And this would allow for parole consideration as long as specific criteria is met. And that would include no conviction for a violent felony, completion of at least 6 years of the sentence, receiving a low-risk rating for recidivism, achieving a high school diploma or equivalent, no serious disciplinary infractions within the past 12 months. This has been rolled out, as you might have seen in media reports, with great praise for the impact that this has had for sentences that were previously made under recidivism statute or extended sentences which were previously required in Georgia. Under Part 10 of the legislation, it provides guidance for licensing boards along the lines of ban the box policies that have been put in place, and for specific consideration to be given for licensing boards so that a determination can be made about whether or not the offense at issue directly relates to the license that's being considered. Part 11 of the bill is an addition that was placed in by the House Judiciary Non-Civil Committee, and this was a recommendation made by the Council concerning eligibility for public assistance when a person had a prior felony conviction. Georgia is one of just a few states that currently has such a restriction in place, and the Council submitted that it is important that we address this in the spirit of criminal justice reform and achieving our objectives. Part 12 of the bill would allow for the transfer of supervision of 17-year-olds who are serving currently under the supervision of DJJ on a designated felony sentence or similar sentence to the Department of Community Supervision. And Part 13 would simply change or remove the use of the word diversion center, which I understand is no longer applicable. Ladies and gentlemen, I would like to argue to you and submit to you that the work that's been done by this body, this General Assembly, with the governor's leadership and recommendations in criminal justice reform has shown the state of Georgia to be an example and a model for how we can be smart on crime and criminal justice, and we can cost effectively ensure that the citizens of our state remain protected while we're being very intelligent about working toward ensuring that individuals in custody move toward getting their life on track and again becoming a productive member of society. I would ask for your favorable consideration. Madam Speaker, I'm happy to answer any questions.
The gentleman does have questions. Chair recognizes Representative Kidd for a question.
Gentleman Hill, thank you, Madam Chairman. Hill,
Yes, sir.
can you briefly explain to me what happened to a 17-year-old kid who had a glass of champagne at his girlfriend's house on New Year's Eve? He gets stopped because he had a broken tail light, and the officer says, "Have you had anything to drink?" He says, "Yes." And so he tests, and he tests .002, but because he's a minor, he gets a DUI. No damage or anything, he just gets a DUI. Is that addressed, is any help for that individual addressed in your bill?
So under Georgia laws, at 17, he would actually be charged as an adult. But the way that the bill might address what you're referencing, sir, is record restriction would now be possible for individuals who are charged with minor in possession of alcohol, whereas it was not possible before, after the expiration of a certain period of time.
One last question, if I may.
Yes, sir.
Is there any way under your bill for expungement of his record, of his DUI that was .002, so it wouldn't affect him trying to get a job later on or get into law school or whatever else as it does today?
I think under the circumstances that you've outlined, there would be an opportunity both in state court or even a juvenile court for an operating under the influence accountability court, for the judge to implement rigorous standards to determine whether or not the individual had shown his or her steps that were taken and work that was taken to get beyond this offense and make sure that there would be no further problems going forward, with an opportunity for the judge to alter the charge after the fact, which might allow for a diversion or something along the lines that I think you're outlining. Records restriction is what expungement is now referred to here in the state. Thank you.
Chair recognizes Representative Morris for a question.
Thank you, Madam Speaker. Does my friend yield?
Yes, sir.
Section 11, I want to make sure I understand. Current law states that a convicted felon of drug offenses has a lifetime ban on receiving food stamps. Is that correct?
Yes, sir. That's my understanding from the House committee. It is the testimony that we received, though, is that the Criminal Justice Reform Council determined that it's inconsistent with the individual having an opportunity to get back on a law-abiding track if he or she is on probation or parole, just out of custody, and unable to move toward a law-abiding life where there aren't future run-ins with the law.
Would you further yield?
Yes, sir.
So just to make clear, if I vote for this piece of legislation, part of what I'm voting for is to allow a person who not only has been convicted of a felony drug offense, but a person who is actually serving a sentence as a convicted drug felon. While they are serving their sentence, they will be eligible for and they will receive food stamps?
Well, no, sir. While they're in custody, they are not eligible. They are absolutely not eligible while in custody. The circumstances of eligibility are outlined in Part 11. But certainly while they are incarcerated, they are not eligible.
Would you further yield? Okay, but while they're in prison behind bars, they're not eligible. But while they are serving a probated sentence outside of prison, then they will be able and eligible to receive taxpayer-funded food stamps. Is that correct?
Yes, sir, that's correct in that it's consistent with the majority of other states where such assistance is permitted, and it's being done with a mindset toward ensuring that they aren't drawing greater public assistance long-term or potentially receiving benefits in other areas because they are not on a track to have become a productive tax-paying member of society.
So to make sure I understand, if you further yield, the council determined that they would be better receiving food stamps and getting back in society on public assistance.
Yes, sir. The council determined that that Part 11 of the bill is beneficial toward the objectives in criminal justice reform, ensuring that these offenders have a life that going forward is law-abiding, where they are a productive member of society. Part 11 of this legislation, the council felt, gives those individuals the best chance of that taking place, ultimately being less of a detriment to Georgia taxpayers.
Thanks, sir.
Yes, sir.
Chair recognizes Representative Ballinger for a question.
Thank you, Ms. Speaker. Does the gentleman yield?
Yes, ma'am.
Isn't it true that Alabama, Texas, and others who are hardly soft on crime also allow for offenders to be able to receive food stamps while they're traveling that arduous road to recovery?
The lady knows of what she speaks.
Does the gentleman further yield?
Yes, ma'am.
Isn't it true that somebody who's currently convicted, maybe serving a probated sentence for an offense such as aggravated battery, aggravated assault, or one of those other heinous forcible felony crimes, is it not true that they're also eligible for food stamps at this time?
Yes, ma'am.
Thank you.
There are no more questions.
I yield the well and ask for your favorable consideration. Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of the bill. The yeas were 166, the nays were 1. The bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to Senate Bill 307.
Senate Bill 307 by Senator Beach, the 21st, Williams the 19th, Butler the 55th, Parent of the 42nd, Gooch the 51st, and others to be entitled an act to amend Code Section 32-6-51 of the Official Code of Georgia, annotated, relating to erection, placement, or maintenance of unauthorized structures within rights-of-ways of public roads. This bill having been referred to the Committee on Transportation. The committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Coomer to present the bill.
Thank you, Madam Speaker. Senate Bill 307 modernizes the code as it relates to advertising signs on bus shelters. It requires the same operational standards as digital signs already in code, such as proper brightness levels, no obscene materials, and fixed images for 10 seconds, no flashing screens, and no sound. It does provide for local control to remain in place. If a local ordinance prohibits these types of displays, then that ordinance would take precedence. The bill also has an amendment that we've added in the Transportation Committee. The amendment is the language from House Bill 973 that y'all passed out of here back on February 26th. And that's a bill that went over to the Senate, and they put it in a committee and would never give a hearing to the bill, so we're going to make them deal with it one way or the other. I ask for your favorable consideration.
There are no questions.
Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? Chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of the bill. The yeas were 143, the nays were 17. The bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to Senate Bill 85.
Senate Bill 85 by Senator Beach of the 21st, Jenna of the 47th, Gooch of the 51st, Mullis of the 53rd, Albers of the 56th, to be entitled an act to amend Chapter 62 of Title 36 of the Official Code of Georgia annotated relating to development authorities so as to revise the definition of projects as applicable to said chapter. This bill having been referred to the Committee on Government Affairs. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Raffensperger to present the bill.
Thank you, Madam Speaker. I bring before you today SB 85, which is actually in its entirety is HB 781, which passed here over a week ago, clearly 2 weeks ago. What this bill would do was establish some rules and regulations order to who gets appointed to government boards, commissions, and authorities. Basically, it's looking for you to be a citizen or national of the United States or a lawful permanent resident and legal resident of the state of Georgia, with several exceptions, such as being an active duty member of the armed forces. It's the same bill that we passed a few weeks ago on a late Friday afternoon, so I'll be brief today. There isn't a minority report, and I would like to say that there is no certain time period in this bill and does not require citizenship. Citizenship is one of the things that would make you eligible for a board, but also permanent, lawful permanent resident status. I'd ask for your favorable consideration. I yield the well.
For what purpose does Chairman Martin rise?
Parliamentary inquiry, since the gentleman wouldn't stand for a question.
State your question.
I believe I heard the gentleman correctly, but is it true, Madam Speaker, that this bill has been substituted in its entirety and contains none of the language from the original Senate Bill 85?
I'm sure the gentleman knows of which he speaks. There is a minority report. The chair recognizes Representative Oliver to present the minority report on Senate Bill 85.
Thank you, Madam Chairman. I also will be brief this afternoon because we spent a good deal of time on this bill. My points previously, and are set forth in the minority report, is that this is an anti-business bill. It's a bill that does not recognize, appreciate, give respect to the international businesses that we recruit with a lot of expense and a lot of effort to Georgia. There are 29 biracial chambers of commerce. There are a dozen international export offices across the world. This is an anti-business bill, not sufficiently respectful of all the economic development efforts we make across this globe. Thank you, Madam Speaker.
Lady has yielded the well. The chair recognizes Chairman Reinders for the chairman's report. He waives. Is there any objection? No. There are no questions. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee which was favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? If so, the clerk will lock the machine. On the passage of the bill, the yeas are 94, the nays are 62. The bill, having received the requisite constitutional majority, is therefore passed.
for it. House will come back to order. House will come to order. The chair recognizes the chairman of the Governmental Affairs Committee, Chairman Reinders, for an announcement.
Thank you, Mr. Speaker, and members of the Governmental Affairs Committee. We're going to be right there in that ante room, and then we're going to find us a room so everybody's listening that's got a little interest in DeKalb County. We're going to take that up in just a few minutes. Thank you, Mr. Speaker. I'll let you know the room in just a second.
Chair recognizes Chairman Reinders for an announcement.
Thank you, Mr. Speaker. Room 216 downstairs, Governmental Affairs. 216 downstairs. Thank you, Mr. Speaker.
This House will come back to order. Chair recognizes Representative Hawkins for a motion.
Mr. Speaker, I move to disagree to the Senate's substitute to House Bill 768.
Clerk will read the caption.
House Bill 768 by Representative Hawkins, the 27th, Willard, the 51st, Flood of the 64th, and others, to be entitled an act to amend Title 30 of the Official Code of Georgia annotated relating to disabled persons so as to provide for the establishment of a qualified ABLE program in this state.
Chair recognizes Representative Hawkins to explain his motion.
It's not on? Yeah, there it is. Okay. The Senate added a little part on the end of the bill that I think needs further discussion, and I think that'd be best handled in the conference committee.
On the gentleman's motion that this House disagree to the Senate amendment to House Bill 768, is there any objection? Hearing none, the House has disagreed to the Senate amendment on House Bill 768. Chair recognizes the chairman of the Transportation Committee for an announcement.
The Transportation Committee will be meeting in Capitol 218 right now.
Chair recognizes Representative Quick for a motion.
Thank you, Mr. Speaker. I make a motion that this House do agree to the Senate substitute to House Bill 52.
Representative Quick has moved that this House agree to the Senate substitute to House Bill 52. The clerk will read the caption.
House Bill 52 by Representative Quick of the 117th and others to be titled an act to amend Code Section 19-9-1 of the Official Code of Georgia annotated relating to parenting plans.
Chair recognizes Representative Quick to explain the Senate substitute.
Thank you, Mr. Speaker. The Senate changes to this bill. This was the parenting plan measure which made it clear that the administrative office of the courts rule would not stand in place of this House and Senate statute in terms of what a parenting plan was, and that a separate order would not be required. The change that was made in the Senate was exactly the change that Chairman Willard requested and that I promised I would have the Senate make, which was to leave no doubt that the parenting plan factors would need to be addressed by the court, but that a separate court order redundantly and duplicating paper and time would not be required. And that's the change, Mr. Speaker.
You have no questions. On the lady's motion that this House agree to the Senate substitute to House Bill 52, all those in favor of the motion will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the motion that this House agree to the Senate substitute to House Bill 52. The ayes are 151, the nays are 0, and this House has agreed. Chair recognizes the chair of the Health and Human Services Committee, Chairman Cooper, for an announcement.
Thank you, Mr. Speaker. Could I have the members of the House Health and Human Services Committee meet me in the anteroom for one of the briefest meetings that we've probably ever had? So all House and Health Service members, Human Service members, meet me in the anteroom right now. Thank you.
Chair is announcing that Senate Resolution 954, Senate Resolution 954 will be postponed until the next legislative day. Chair recognizes Representative Petrie for a motion.
Thank you, Mr. Speaker. I move that we accept the Senate Subcommittee's version of my bill, House Bill 509.
You mean to accept the Senate substitute?
Substitute, I'm sorry, sir.
Is that accurate? Okay, you can step out of the well. Representative Petrie has moved that this House agree to the Senate substitute to House Bill 509. The clerk will read the caption.
House Bill 509 by Representative Petrie, the 166th Stevenson, the 164th, and others, to be entitled an act to amend Chapter 7 of Title 31 of the Fiscal Code of Georgia, annotated, relating to health care facilities so as to implement initiatives to improve quality and delivery of patient-centered and family-focused care.
Chair recognizes Representative Petrie to explain the Senate substitute to House Bill 509.
Thank you again, Mr. Speaker. I am completely supportive of the changes that were made by the Senate and have discussed those with my Health and Human Services chair as well. I will very briefly explain what they are. As you may recall, we had a palliative care advisory committee that was going to be comprised of 9 members. They still are 9 members. In my bill, they would be appointed by the commissioner. The Senate wanted to change that, and we have agreed, as has the MAG and the American Cancer Society. The appointments now will be made by the chairperson of the House Committee on Health and Human Services, the chairperson of the Senate Health and Human Services, 2 members appointed by the Speaker of the House, 2 members appointed by the President of the Senate, and 3 members appointed by the Governor. So the Senate wanted legislative oversight of this body, and that is the first and major change. Second change that you will note is that there was some additional language added at the Senate's request on how reimbursements are made to individuals who serve. The language now says any legislative members of the council shall receive the allowances provided for in Code Section 28-1-8, and that relates to any legislative members. And then citizen members shall receive a daily expense allowance and the amount specified in subsection 45-721. So that is pretty much consistent with what we had before, but they wanted to explain it better and use language that is customarily used. The final change is a change that I made. My friend from Athens had made some recommendations on some language that we removed. The previous bill had lines 78 through 80. The department may develop and implement any other initiatives regarding palliative care. I had all of that struck from the bill. And those are the changes, Mr. Speaker. They keep this bill intact. This still does the good work that I believe it will do. And I hope that everyone will support these changes.
You have no questions. On the gentleman's motion that this House agree to the Senate substitute to House Bill 509, all those in favor of the motion will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion that this House agree to the Senate substitute to House Bill 509, the ayes are 140, the nays are 7, and this House has agreed. House will come to order. This House will come to order. The chair momentarily will recognize Representative Tanner for a motion. Before I do that, I want to say that even though there is no requirement in the rules of this body prescribing an amount of time that a measure should lay on the table, that I have committed and will honor that commitment that it be on the desk for an hour. And actually, I'm advised now it's been on the desk for about an hour and 40 minutes. So I wanted everyone, because of the gravity of the issue and the level of interest in the issue, to be able to have the document before them as we go through the debate. What purpose does the majority leader rise?
Mr. Speaker, I move to temporarily suspend the rules of this House to allow debate on Representative Tanner's motions with the time to be determined by the chair.
Majority Leader has moved that the rules of the House be temporarily suspended to allow debate on this motion with the time to be determined by the chair. Is there objection? Chair hears none, and it is so ordered. In keeping with the practice of the Rules Committee on measures that have great interest, the chair will limit debate to a total of 1 hour. The proponents will have 30 minutes, and those opposed will have 30 minutes. Chair recognizes Representative Tanner for a motion.
Thank you, Mr. Speaker. I move that this House agree to the Senate amendment to House Bill 757 as amended by this House.
Representative Tanner has moved that this House agree to the Senate substitute to House Bill 757 as amended by the House. The clerk will read the caption.
House Bill 757 by Representative Tanner of the 9th, Nix, the 69th Battles, the 15th, and others, be titled an act to protect religious freedoms, to amend Chapter 3, Title 19 of the Official Code of Georgia, annotated relating to marriage generally, so as to provide that religious officials shall not be required to perform marriage ceremonies in violation of their legal rights to freedom of exercise of religion.
Chair recognizes Representative Tanner to explain his motion.
Thank you, Mr. Speaker. As you recall, a month or so ago, we brought before this House, House Bill 757, pastor protection, and we were able to vote that out unanimously out of this body. Coming together with a consensus that we all agreed on. It was sent over to the Senate. They made some changes to the legislation. It's been back before this body for either an agree or disagree. Before I start explaining what you have before you as this sub-Senate or the House amendment to this Senate substitute, I want to take just a moment to thank not only the Speaker, and I want to thank the Speaker for his leadership in this area really over the past year as we've tried to find a way to create a compromise. And I also want to thank his staff, Spiro, Caleb, and Terry Chastain. They've worked tirelessly on this effort. They have met with me and others in this body numerous times, with Senate leadership and others from all different aspects of these communities that have concerns, and I appreciate their efforts. A lot of people maybe don't get to see what they go through, but I personally have, and I appreciate what they've done here. You have the bill before you, and I'm going to try to go through that, and then we'll move on. This is a comprehensive measure that's based on the Pastor Protection Act in an attempt to protect clergy and faith-based organizations as well as individual citizens by incorporating elements of several bills. If you look through the amendment, you will see that this takes in part of the FATA language, part of the RFRA language and part of the passenger protection language in an effort to reach a consensus. The bill has been entitled the Free Exercise of Protection Act. The Section 2 of the bill covers primarily the passenger protection that we passed out of this chamber a while back as House Bill 757. That is Section 2. Section 3 again was passed in passenger protection. It deals with not requiring a business to be open on Saturday or Sunday. I will tell you I've had some questions about why we chose Saturday and Sunday, and I will point you to current law already provides for those 2 days as the days of rest to protect employees from being required to work on those days if it violates their personal religious beliefs. So we just extended that protection to include the business owners themselves from being required to do that through local ordinance. Section 4 deals with protecting faith-based organizations, property, and services. They're not required to rent, lease, or otherwise grant permission to use property in an event which is objectable to their faith, and they cannot be required to do that unless they voluntarily enter into a contract. I think it's important to note that any of these organizations that enter into a voluntary contract, as part of that contractual arrangement, they're agreeing to perform a service. We're not giving them an out from that contract. They would still have to abide by the terms of that contractual agreement. If they refuse to provide or rent space, this cannot be used to deny them a tax abatement or a tax. They cannot get a tax penalty, I guess is the correct way to say that, from their refusal to do that. If they feel like they've been wronged by the government, then they can bring action in accordance with the bill. Section 5 is protecting faith-based organizations from employment decisions. This just states that a faith-based organization cannot be required to hire or retain any person whose religious beliefs or practices or lack of either are not in accord with those of the faith-based organization. Refusal to hire or retain will not result in any civil penalties as outlined in the bill. Section 6 brings in some of the RFRA language that you saw before. It says the government shall not substantially burden a person's exercise of religion, even if the burden results from a law, rule, regulation, ordinance, or resolution, unless it demonstrates that application of that burden is, and there's a couple of points there I think it's important for you to note. Number one, in furtherance of a compelling government interest and the least restrictive means of furthering that compelling government interest. Then it goes on that a person whose exercise of religion has been burdened may assert that a violation of that claim is a defense in court to obtain declaratory judgment. So there's a method for them if they feel like a city, county, or a government entity has forced them to violate their faith. They have a method in court to get. And then it goes on, Section 7 waives sovereign immunity to the extent that it would be required for these persons to seek relief against the government. In essence, that's the legislation. I will tell you that this has been a long process, worked very closely with our friends in the Senate and others to try to come up with a compromise that accomplished protecting those of us who live in communities that have strong faith-based communities, that people are concerned about the times that we live in and the changing times that their faith is being questioned and their ability to act on their faith is questioned, but at the same time not allowing for very overt discrimination and keeping Georgia the #1 place in the nation to do business. And I think we've reached that with this legislation and this amendment. And Mr. Speaker, I would ask that everyone in the House join us today in sending that message to all of Georgians and that we all vote in favor of the amendment that's before you. And I'll be glad to answer a couple of questions.
Do you yield?
Yes, sir.
Chair recognizes Representative Peake to your right for a question.
Does the gentleman yield?
Yes, sir, I do.
Representative Tanner, is it not true that this bill represents a very personal issue for many of us, because all of us have someone in our circle of life who may be gay? Is that not true?
Yes, sir, I believe that's correct.
Is it, further yield?
Yes.
Question. Is it not true that this bill does not in any way, shape, or form further enhance or strengthen ability of the owner of a restaurant or a hotel to deny service to an individual just because of their sexual orientation?
That's correct.
Okay. Thank you.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes Chairman Parsons to your left for a question.
Thank you, Speaker. Does the gentleman yield?
Yes, sir.
I'd like to ask, if I could, on page 3, lines 93, 95, says no faith-based organization shall be required to provide social, educational, or charitable services that violate such faith-based organizations' religious beliefs. Well, that's pretty straightforward, isn't it? That just means that if there's something that they don't want to teach, some particular issue or some particular act or anything else, they wouldn't have to do it. Isn't that correct?
That's correct. And a faith-based organization could include a Christian school or another particular religious school.
And if I could, further question.
Yes, sir.
On page 3, or page 5 rather, 134 through 138, it says no faith-based organization shall be required to hire or retain as an employee any person whose religious beliefs or practices or lack of either are not in accord with the faith-based organization's sincerely held religious beliefs as demonstrated by practice, expression, or clearly articulated tenet of faith. Is that what it said?
Yes, sir.
But now isn't that allowing for that faith-based organization, that is providing for discrimination with that organization? Isn't that true?
I'll give you an example. If you had a Christian school, 501c3 Christian school nonprofit, and someone came to them that was of a different faith that applied for a teaching job, then under this they could deny that person a job. That is correct.
Would it only be, if I may, and I'll sit down in a second, but would that only apply to, that doesn't just apply to religious beliefs though, does it?
It would be in accordance with their closely held religious beliefs. And also, I'll point out to you, except as provided by the Constitution of this state or the United States or federal laws. So if there are other laws that are governing that area, then they could not do it. But absent additional laws in place to protect, then yes, they could.
Just one more, if I may. So federal law, does that include the federal laws that apply to hiring practices as far as minorities, so on and so forth?
Correct.
Okay, thank you, sir.
That's correct. Mr. Speaker, with that, I know there's other speakers signed up, I believe, to speak on this, and I know the time is drawing short tonight, so I would ask that you give careful and favorable consideration to the amendment that you have before you for House Bill 757. Thank you, and I yield the will.
Chair recognizes Chairman Randy Nix to speak to the bill or the motion.
Thank you, Mr. Speaker. You know, as I come down to address this issue, this is something that we have had on our plates here for quite a while. And I know that it is a very emotional issue. And it probably should be, no matter which side of the issue you may come to. But we have to address it in the most careful manner. You know, there are bumper sticker solutions to just about everything, but have you ever found a bumper sticker solution that worked? Very seldom is it going to work. When we just had a discussion about this in the caucus, with 120 different people, we probably could have had 120 different bills. But at some point in time, we've got to drive a stake in the ground, and we've got to all connect ourselves to that stake and say, okay, here's where we are. We believe that this has the best of what everybody can put into it. Nobody's getting everything they want. But we've got to come together, and I think we need to do this for the state of Georgia. As a Christian, I have strong feelings about it. But as my friend Representative Peake has mentioned, I have some gay members of my family.
And you know, I love those boys a lot. And the last thing I would ever want to do is to see them be discriminated against because of that, because I watched them grow up and they did not choose what they happened to be. But I think this bill has addressed as fairly as we can that very strong passion that I have that says, I don't want to participate in that gay marriage. It doesn't say that I say that they can't do it. It just says that I have no desire and feel that I should not be asked to be a part of it. As I thought about this, and when we get through, there will be a lot of cheering on one side and maybe not on the other. I was thinking about a football game. You know, when you have a good football game going and somebody scores, both sides of the stadium make noise. Some may be yelling yay and some may be yelling boo, but there is a big noise that comes about it. Let me kind of close with this thought, and this thought came to my mind. I was scrambling on the computer trying to find it. T.S. Eliot made a quote, and I'm probably going to mess this up, but this was about the church, and I think we can apply it to us. He said that the church could neither be too conservative, too liberal, nor too revolutionary. If we're too conservative, we may conserve the wrong things. If we're too liberal, we may relax our disciplines. And if we're too revolutionary, we may deny the permanent things. Mr. Speaker, I think that we have walked that fine line down the middle. And I too want to thank the people that have worked so hard on this. I have not been out front pushing, but I have been behind the scenes talking to the Speaker, talking to his staff, and I feel good about what we've got here. And I certainly hope that you will step up and support this measure. Let's put it behind us, and let's move forward to continue to make Georgia the best place to live and to work and to raise our families and to live out our faith. I yield the well.
Chair recognizes the chairman of the Ways and Means Committee, Chairman Powell, to speak to the bill.
Thank you, Mr. Speaker. I rise to support this bill, and I want to tell you it hasn't been an easy journey from when we started this last year up until this point. We've seen bills, we've seen suggestions, we've seen lots of different options and alternatives, and all of them had drawbacks one way or another. But today, we see a balanced approach, something that protects religious liberty without authorizing discrimination. It protects our clergy. It protects our religious and faith-based organizations. It protects the individual. It is balanced. Is it perfect? No, it's not perfect. But I challenge you to find a perfect piece of legislation that's ever come out of this body. They don't exist. What we can do and what we have striven to do is to do the very best we can for all of Georgians. We have listened to the faith-based community. We have listened to business organizations. We have listened to the gay part of our community. We have listened to everybody. Is everybody going to be happy with this? No. Is anybody going to be happy with this? No. Which means that it's probably the best we're going to get, because if you don't make everybody happy, and if nobody is happy with this, I do a lot of domestic work, and generally I feel like that we've got a pretty good agreement if everybody hates it. This bill that we see strikes a very fine balance. and we need to deal with it today. We need to pass it. We need to be done with it. We need to show our faith-based community that we're listening to them. We need to show our business community that we're listening to them. We need to show our gay citizens we're listening to them, and this strikes that balance. I encourage you to support this legislation. Mr. Speaker, I yield the will.
Chair recognizes the Majority Leader of the House, Leader Burns, to speak to the bill.
Thank you, Mr. Speaker. Today I rise in support of this proposed amendment to House Bill 757, and I'd like to take this time to thank our Speaker. He's exhibited the best qualities of leadership over the last couple of years as he's helped us wrestle with this issue. And today, we have a form that I think is correct. As yours is to you, my faith is very important to me and my family. I want my faith to be seen in my actions and the example I set for others. In my family, we strive to treat everyone as we would like to be treated. That's how I raised my boys. That's how I was raised, and that's how my boys are raising their children, my grandchildren. Today, I cannot, in good conscience, support any measure that infringes on anyone's religious liberty. And at the same time, I will not support any measure that permits either directly or indirectly the unjust treatment of others. To do so in either case would violate not only my own values, but those embodied by my oath of office. Since this progress started, we knew it would be an effort to get it right. And during that time, I have wanted this legislature to do one thing: find the right balance between protecting religious freedom and respecting the dignity of all individuals. I believe this amendment strikes that balance. This bill protects the minister. It protects the church, the big city church and my little country church. It protects faith-based organizations. It protects the individual's right to worship in accordance with the tenets of his or her faith. It protects the family to worship as it sees fit. And I sincerely believe it protects the individual's dignity and right to live and conduct business in this state. A few years ago, President Franklin Roosevelt said everyone in the world should have 4 basic freedoms: freedom of speech, freedom of worship, freedom from want, and freedom from fear. This amendment will ensure that those 4 freedoms will protect all Georgians. And I sincerely believe this is the right bill for all of God's children. Mr. Speaker, I yield the will.
Chair recognizes the Chair of the House Transportation Committee, Chairman Coomer, to speak to the bill.
Thank you, Mr. Chairman. I rise today in support of the motion to agree that's before the body. And I remember a few years ago, before I was involved in politics at all, I was a student actually, I remember the Democratic Party of Georgia had a campaign slogan that said, if you love Georgia, what? Thank a Democrat. Y'all remember that, don't you? If you love Georgia, thank a Democrat. Now, I was a Republican then, and I hated that slogan. And the minority whip says it was true. But I didn't like it because I had to acknowledge that the state that I loved had been under the guidance and the control of a party that I didn't really agree with a lot of the times. But I have to acknowledge really the brilliance of that political strategy, which was to make people understand that the state that they loved was had been in the hands of that party organization and been under the leadership of that group for many, many, many years. Now, what has that got to do with what I'm going to talk to you about? That's a good question. I'm going to get right to it. I want to draw your attention to really what is the only new section of this legislation, because you've seen the Pastor Protection Act that we passed out of here unanimously a few weeks ago, and you've seen various versions of the First Amendment Defense Act that came back from the Senate, and we have some provisions in there on that. And you've seen the language in the Religious Freedoms Restoration Act that we've talked about. But the thing that you haven't seen is really at lines 207 through 212. Line 207 says that with respect to interactions which affect the rights or interests of third persons, this chapter shall be construed consistent with Article 1, Section 1, Paragraph 3 and 4 of the Constitution of Georgia, and consistent with decisions of the Georgia Supreme Court made pursuant to said paragraphs. Now, let me tie this back to my original comment. We're giving a guidepost here to the courts of this state that when they interpret our meaning in passing this legislation, they are to go back and look at our Constitution and the Supreme Court decisions that govern. And the seminal case on this issue is Jones versus the City of Moultrie. That was a 1943 decision that interpreted the Constitution as existed at that time, the Georgia Constitution, to say that your right to exercise your religious beliefs ends at the point that it interferes with the rights of others. That was in 1943. Well, I have to tell you, every member of the Supreme Court in 1943 had been appointed by a Democrat governor. The Constitution at that time had been adopted by Democrats. And my point in all that is to say, when you think about if you love Georgia, think a Democrat, we're really relying back on the same principles, the same ideas, the same thoughts that have been governing this state for nearly 100 years now, and that is that we believe in the basic philosophy of live and let live. And part of living is exercising the religious liberties, the strongly held convictions that you've been given, either through your experience in your family and church or through your own personal religious experience, your salvation experience. Whatever that is, you ought to be able to believe what you want, and you ought to be able to exercise the tenets of your faith in the way you see fit. But there is a limit on that, and the limit is you can't invade the rights of others when you do it. That's what lines 207 through 210 says. Line 211 and 212 make it clear. And I want everybody to hear this. Makes it clear. Nothing in this chapter shall be construed to permit invidious discrimination on any grounds prohibited by federal and state law. In other words, for those who have in the past said that this whole exercise is about allowing and authorizing and codifying and approving some kind of discrimination or discriminatory practice, your answer is in lines 211 through 212. Nothing in this chapter will be construed to permit that kind of discriminatory behavior. Mr. Speaker, I know that I could go on and talk about the other parts of the bill, but I think there may be some questions, and I'm willing to stand for a few questions if there are any.
You have a question, or did you were speaking?
Okay.
Okay. You have no questions.
I yield the will.
Chair recognizes Representative Hightower to speak to the bill.
Thank you, Mr. Speaker. I want to talk to you briefly, not necessarily about this bill, but how this bill came about. A lot of times in these positions, we get a lot of bad press about we're not doing things fast enough, we're not doing things the right way. And unfortunately, at times, there are certain people in leadership who have to bear the brunt of that. One on this particular bill was our speaker. And I assure you, he and I don't always see eye to eye on certain bills. And he's allowed me the liberty to express to him my concerns at times, and he's definitely told me his concerns. But on this particular bill, I know last year, myself along with 5 or 6 other House attorneys met with the Speaker on 2 or 3 different occasions working on this bill. I know this session we had 5 or 6 different House attorneys meet with the Speaker working on this bill, working with his staff, working with his people, trying to make it right. The whole time he was trying to bear the brunt of the heat that nothing may pass, that we weren't going to do something to help Georgia. And I know a lot of our caucus members at times got frustrated and didn't know where we were going. But I did want to take a minute because a lot of the people out there, our constituents, they don't always see the work that goes on to get the end result. And I assure you, this bill has been worked on extensively and methodically to get us to a place where we need to be. I spoke with a couple members earlier, and the example that was given to me is if we remove all this stuff that we've heard over the past 2 years and all the anxiousness that we have and all the timidness we have on this bill, and we were just delivered this bill to begin with right off, I don't believe anyone would be concerned because this is a good bill. This is a good compromise, and this gets us exactly to where we need to be, in my opinion. And I want to take the opportunity to thank every member of the House that's been with us in those meetings, the Speaker, Representative Kelly, Representative Golick has been in those meetings, Atwood has been in those meetings, Representative Fleming has been in those meetings. I could go on and on to the representatives that have helped contribute to get us where we are. And I just want to take this time to thank them because sometimes when they're out in front and battling the front lines for us and taking the heat, they don't always get those things. And on this particular bill, for us, I think it was definitely needed. And I want to take an opportunity to thank you, Mr. Speaker, for letting us vote on this bill.
Chair recognizes for the final minute Chairman Setzler to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I hear the chuckling out there. I'll keep it very short. Well earned, I'm sure. I just wanted to thank folks who have been involved in this. There's some people in the halls and across the building that may not be happy with this bill, but I can tell you, as the folks said before me, there's so much good in this, and it's so balanced. Appreciate the work on this. This is a balanced bill, and what the RFRA portion of it simply does is it simply takes 23 years of case law, although we all enjoy the protections we have from the federal government being able to intrude on our personal rights, and applies it to state and local government at the local level. It's been done broadly, happens on our military bases, and that protection is important. And what's important about it is it doesn't guarantee things, but it guarantees that someone's right of free exercise, when it collides with other interests, it gets a fair shake and is fairly balanced. And that's an important thing for us to do here. Appreciate the leadership, appreciate people in both parties who've been ladies and gentlemen about this, and I would urge this body's strong consideration in support of the motion to send HB 757 to the Senate with a very strong do-pass vote. Thank you, Mr. Speaker. I yield the will.
The time for those seeking passage of the bill or speaking in favor of the bill having expired, the chair now will reset the clock, and the chair recognizes Representative Drenner to speak to the bill.
Thank you, Mr. Speaker. Well, I didn't wake up this morning thinking that this was what I would be talking about today, or I would have worn a black suit and something a lot more representative of what I feel today is all about. I've been here in the House. This is my 16th year. And I look back and I think, man, time flies when you're having fun, doesn't it? I came in, I was in the majority party. I didn't even know what that meant, to be in the majority party. But I was there for a brief moment in time. I didn't run to be the first gay anything. I'm just me. I remember when I was first elected, my mom said, "Why did you tell people?" I said, "Well, I can't imagine lying. I can't imagine not just being me." And today's conversation that I'm going to have with you is really just about being me. It's about not making apologies because I'm who God made me to be. Just me. I've never been an activist. I worked in corporate America. All of a sudden, well, I'd go to rallies, and I'd never been to a rally. You're supposed to rah-rah this and stand for that, and that just really wasn't my experience. I'm a quiet, introverted person. I know, it's true. Academic would prefer to watch movies and read books than to go to parties, unless they have good wine. And then maybe I might show up. So being put in a position to represent a community in addition to my district was a really different experience for me. In 2004, I was here when we had the constitutional amendment fight, and boy, that to me was a very, very hard year. After the session, I volunteered to help with the statewide movement. And I can remember going up to parts of Georgia where I was listening to the radio station where one candidate was debating the other candidate about how bad they hate gay people. And I walked in that radio station and I'm thinking, what? No, I hate them. No, I hate them. And I'm standing there thinking, oh my gosh. So I understand the significance of this issue. I never believed in this lifetime same-sex marriage would be legal. I never thought that. And it is. And I know it's scary for a lot of people, because when I listen to your debate, it's painful. It hurts my heart, because I can't understand how your world is changing. Because for me, now I know marriage is legal, but for me, I would never want to go into your church and demand somebody marry me. I would never want to go to a restaurant that wouldn't serve me. That to me just sounds reasonable, right? And so when I think about this issue, I think, why do we need this? Because reasonable people don't do those things. Balanced, I don't think it's balanced. I think this is really unbalanced. Because what it says to me is that there's something wrong with you, Carla. There's something wrong with your family. There's something wrong with your faith. Do you think for a minute that to be down here for 16 years, you didn't have to have faith in the Lord to be down here? Well, I can tell you this, even though I was in the majority party when I was first elected, I definitely wasn't treated like I was part of the majority. In fact, there were people that would not ride the elevator with me. They would look at me and they would say, "I'll take the next one." Now, I know I'm intimidating. I am. Well, maybe academically, but not physically. Well, unless I thought we had 30 minutes. I've talked for a long time then. I guess I had a lot to say. We've been going through this for 3 years, and so I've had a lot of opportunity to think about this. So it shouldn't surprise you today that I oppose House Bill 757 as amended by the Senate. And I oppose it for a lot of different reasons. My colleagues in the House and our community have been extremely patient and cooperative throughout this process as this assembly has navigated a course to try and reach a mutual understanding on religious liberty, or as I would remind this body, human rights. I have been respectful in our discourse, and I have been thoughtful in my dialogue, and I have made my position known that any religious freedom legislation can, should, and must contain anti-discrimination language to protect all Georgians and uphold all rights. In fact, for the last 5 years, I have introduced a Fair Employment Practices Act with 69 signatures, and I have never gotten a vote on that bill at all. The public accommodations bill that Chairman Golick introduced, there was a move to add sexual orientation, and it was struck down in committee. I have been supportive of this bill. I was supportive of the pastor protection bill when it left this chamber because I respect an individual's right to hold his or her own personal beliefs. I did not demand acceptance. I demanded respect. And in its original form, this bill afforded all parties respect. I want to thank the Speaker and this body for that. We demonstrated how we could work together on this. But then this bill came back to us with new language, a language I can read, a language I can understand, but a language I will not speak. Because, ladies and gentlemen, this language does away with the idea of mutual respect, and it replaces it with a license to discriminate against a community of Georgians who contribute a great many things to our society, our economy, and yes, our way of life. This bill says that I am not as much of a citizen as my neighbor. This bill suggests that at my core, there is something offensive about who God made me to be. It says that my neighbor and I are held to different standards of how we treat one another. It says that the members of the LGBTQ community can vote for our representatives with the rest of Georgia, but we cannot enjoy the same measure of respect as those we send to higher office. House Bill 757 says that the gay homeless youth may be denied shelter by a religious organization. It says that a lesbian mother may be refused service by a faith-based school. It says that somehow members of the LGBTQ community are less, and it most certainly does not take the time to state otherwise. It says that my rights under the Constitution, under the law, and under God are inalienable, but rather are subject to the opinions and beliefs of others. Well, ladies and gentlemen, I disagree wholeheartedly. And as surely as I stand in this chamber and vote alongside you in making this state a better place for all, I stand here today to urge you not to walk back from that goal, not to abandon that problem or that promise. When we allow discrimination, no matter how tacitly at first, it opens the door for that discrimination to grow and pervade our best ideals and beliefs and goals. When we allow discrimination by anyone, we don't just harm our businesses, our tourism, our economy, we harm the very people upon which they were built. When we allow discrimination, we abandon our principles, we abdicate our responsibilities, and we forsake our claim and status as an enlightened society. When we allow discrimination in any form, we can no longer call ourselves free, because some of us are not. Freedom is an all or nothing principle. There are no shades of liberty. And when I am not as free as my neighbor, we all lose. I urge you to vote no on House Bill 757, and I yield the well. Thank you, Mr. Speaker.
Chair recognizes Representative Bennett to speak to the bill.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of this body, I rise today to speak in opposition of this bill, House Bill 757 in its current form. This is actually my first trip to the well this session. Upon being elected, I was advised by some, if not everyone, to lay low in my first year, to learn it all and soak it all in, and not ruffle too many feathers. And I believe that I have done that, but I can't lay low today. I can't sit back and I can't soak it all in today, especially not today. As you all know, when we passed this bill, House Bill 757 in its original form, we did it unanimously together. And that was a big statement. And we did that working together in a true display of bipartisanship. I was involved in it directly. But what we sent over to our colleagues over in the Senate, we sent over a shield for our clergy, a shield that we could be proud of. But what we got back today was not a shield, it was a sword that can be yielded to strike down our friends, our neighbors, and even our family in the name of religion. The irony of that is diabolical. So what are we saying to our friends and our neighbors and our family when we create laws that create second-class citizenship? You would think that we've moved past that mentality in our country and in our state. Now, some of you may know this and some of you may not, but I am the son of a gay woman. My mother is gay, and she happens to be with us today. She's been married to her spouse since 2014. And some of you are probably wondering, how is this possible? How can he be the son of a gay woman? You can all join us after we adjourn today for dinner, and we'll be glad to explain to you about the birds and the bees. But before you vote on this today, I want you to ask yourself, what are you telling people like my mother? What are we telling people like Representative Drenner, Representative Waits, Representative Cannon? What are we saying to these people? I'll tell you what we'd be saying. We'd be saying, you can't work here because of who you are. You can't dine here because of who you are. That's what we'd be saying, all because one person may have a different perspective of marriage than another. But it is that perspective that will receive the government stamp of approval over the other. Times have changed, ladies and gentlemen. I always hear this thing that federal RFRA has been around for 20 years. 20-something years. It's changed. Times have changed. New issues have come up. New rulings have come out. We deal with new things every day. This isn't 1993, this is 2016. And we have to start acting like it. We have to start addressing these new issues that we didn't face back then that we face now. Freedom isn't defined by a perspective, it's defined by equality, true equality. But this bill abandons that principle. Don't abandon that principle, and don't be part of the wrong side of history. Vote no today on 757. And with that, Mr. Speaker, I yield the well. Thank you.
Chair recognizes the Minority Leader of the House, Leader Abrams, to speak to the bill.
Thank you, Mr. Speaker. Like my colleagues before me on both sides of this issue, I do not doubt the sincerity of belief that has led to the version of 757 that stands before us. I don't doubt the sincerity, but I have to question the wisdom. Because what are we debating with this bill? Fundamentally, we're debating the primacy of rights. Whose beliefs will triumph and whose will be oppressed? Who will be allowed to stand and who will be forced to bend? And we are using religion as the metric through which we make this decision. But Georgia has a proud history of opposing discrimination, of opposing this balancing test, because our original motto was not for ourselves, but for others. That was the original motto of the state of Georgia. And that was the motto that I think led this body together to stand in unison, regardless of party, regardless of faith, regardless of background. We stood together and said yes to 757. I was proud to lead our caucus to do so. And I come before you today to urge my members and to urge this body to vote no, because we have stepped away from standing together to forcing others to bend. One of the speakers pointed out the lovely language in lines 207 through 210, and specifically line 212 that refuses to permit invidious discrimination on any grounds prohibited by federal or state law. The unfortunate nature of that line is that there are no federal or state laws that would protect. This state has refused to engage those laws. The federal government has refused to enact those laws. And the few localities that have taken the courage to do so are not included in this protection. And so there are no laws from which a person could be defended. This bill does not provide protections. And while there is a glory in lines 207 through 222 laying out what we won't allow, I call to your attention the first 7 pages that say what we will allow you to discriminate based on. And those 7 pages are not wiped out by the good intent of a few lines of script. Those lines cannot erase the harm that this bill can do, because what this bill allows is discrimination. There are no defenses, there are no protections, there's no language, there's no case law, and there's only the goodwill of man and woman to say that this will not be mistaken. There was also language about guideposts to the bounds of discrimination, but when we have to have guideposts, we are usually on the wrong road. I would urge us to step away from this bill because we need not travel this road. The original bill, 757, took us on the right path, and that is the path we should continue on. Another speaker pointed to Jones versus the City of Moultrie, a case that I think is very important for this purpose, and I want to read to you some of the lines, because it says, limitations upon religious activities are not confined to instances where such acts are in the contravention of moral law, as the right to exercise these activities end where the rights of others begin. A person's right to exercise religious freedom, which may be made manifest by acts, ceases where it overlaps and transgresses the rights of others. Everyone's rights must be exercised with due regard to the rights of others. But this bill, for several pages, transgresses on the rights of others under the guise of religion. I come to this well because my first engagement of the conversation of the LGBT community happened in a church here in Atlanta, Georgia. When my parents moved to Georgia in 1989 to attend Emory University to go to the Candler School of Theology. They were studying to become United Methodist ministers. And my parents picked their church not based on simply the fact that we were Methodist, but they shopped. And my parents picked a small white church in Midtown Atlanta that was the farthest from anything I've ever experienced as a black girl from Mississippi. This was a church that was both elderly. It had a El Salvadoran community in the upper room because they needed a place to worship. And we had members that I think when you added the 8 of us, maybe there were 50 people in that church on any given Sunday. We sat on Peachtree and 5th Street, across the street from another larger church. And in the 1980s and 1990s, this church prided itself on having an anti-gay march down Peachtree every year. Every year, people would leave from the sanctuary of a church and march down the street saying, "God hates gays." Now, my parents, who hopefully are not watching this because I'm about to out them, my parents raised me to believe that sexuality, that homosexuality, was a violation of the tenets of our faith. But they also raised me to believe that God makes those decisions and not man and not woman. And so the complicated history I grew up with was one that said that we were attending a church and a part of a faith that welcomed everyone, that sanctioned discrimination against absolutely no one, because in our history, whether it was the history of African Americans or the history of Latinos, the history of the gay community, or simply the history of being oppressed, that discrimination rarely finds an end place once it's started. My parents would tell us that, but it was what they did that stuck with me and stands with me today. Because one year when the march started, my parents gathered the group of us, there were 5 small children, and the elderly members of that church, and we all took signs. We took cardboard signs, and we stood on the steps of St. Mark United Methodist Church holding up signs saying, "God loves gays, welcome to St. Mark." My parents had us do that because they wanted us to understand that you can't simply talk about what you think. It is insufficient to simply hold your truths in your heart, because if you don't speak them aloud, they are not real. And if we believed as a faith, if we believed as a family that discrimination against anyone was discrimination against everyone, then they would have us stand there on the steps of that church, a small band against a mighty march, and declare that there was a place for others. This body is a mighty body, and this language sends a message, and that message cannot fail to be understood by those who are its targets. And it's simply this, that we cannot balance discrimination on the backs of those we force to bend. HB 757 as amended forces a community to bend to the will of others, to accept their discrimination, and to do so with charity. That is not right, that is not Georgia, and that should not be accepted. And I ask, therefore, that this body reject HB 87 as amended. Mr. Speaker, if there are no questions, I yield the well.
Do you yield for questions?
I do.
Chair recognizes Representative Waits to your right for a question.
Thank you, Mr. Speaker. Madam Leader, is it not true that the very premise of this bill is to make it lawful to discriminate?
The very premise of this bill has several pieces. I believe, as we agreed earlier this year, that the original intent in the first 2 sections of 757 permit pastors and other people of faith to maintain their sacraments, and I believe that is entirely permissible. It is protected both by federal law and by the Constitution. I think that the remaining sections, unfortunately, regardless of their intent, create the premise that religious organizations and faith-based organizations are allowed to discriminate in the service of others, and I believe that discrimination is what invalidates this law as non-discriminatory.
Thank you.
Do you further yield?
I do.
Chair recognizes Representative Cannon to your left for a question.
Parliamentary inquiry?
No, you're asking me a question.
Okay. Wouldn't it be true that if this bill is passed as amended in a domestic violence situation, in a same-sex couple, that person could be denied care?
So under the terms of this legislation, if a person seeks support from a faith-based organization, which may be the only type of organization providing domestic violence support in that community, they could indeed be denied service by a faith-based or religious organization. And particularly if that is the only community that offers these services, they would be denied service.
Thank you.
Mr.
You
Speaker.
have no further questions.
Mr. Speaker, I yield the well.
Chair recognizes Representative Kidd to speak to the bill. Gentleman has 3.5 minutes.
Thank you, Mr. Speaker. Ladies and gentlemen, I'll be brief. I have no notes. I grew up in the South, just like many of you did. And growing up, we had names for people. We had slang for people. And we used it all the time, behind their backs and to them. I have a gay brother-in-law. The gentleman who worked for me here at the Capitol for 3 years was gay. I've got a medical doctor friend of mine in Millersville who comes by my office about 3 times a week to get some of the chocolate candy I've got stashed back there. And he's gay. And right after the Supreme Court ruling, he and his partner got married, and I fussed at him for not inviting me. And from the heart, I believe this bill is wrong. I'm not privy to what took place in the Republican caucus meetings. I'm not privy to what took place in the Democratic caucus meetings. I'm only privy to my phone booth. But as I recollect, everybody got together. Everybody in this House got together to agree on the Speaker's bill for pastor protection. And it passed up there with no red mark. And I was under the impression that what took place in the caucus meetings was that that's what we were going to stick to, is what passed this House. And ladies and gentlemen, this is the first time I've come to this well to speak on somebody else's bill. And I urge you to do what we were told in the beginning, that we would stick to the Speaker's bill and it would all be green. So I urge you to vote against the substitute that's come back. Thank you.
Clerk will ring the bell. On the gentleman's motion that this House agree to the Senate substitute to House Bill 757 as amended by the House, all those in favor of the motion will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the gentleman's motion. The ayes are 104, the nays are 65. This House has agreed to the Senate substitute to House Bill 757 as amended by this House. Clerk will read the caption to Senate Bill 369.
Senate Bill 369 by Senator Mullins, the 53rd, Harper the 7th, Watson the 1st, Albers the 56th, and others. Being titled an act to amend Chapter 10 and Title 25, the official code of Georgia annotated relating to regulation of fireworks so as to revise the standard of compliance from explosion to ignition.
Chair recognizes the Speaker Pro Tem of this House, Speaker Pro Tem Jones, to present the bill.
Thank you, Mr. Speaker. Well, the first thing I have to say is this is not a fireworks bill. The bill's in your book, and every word of the original bill was taken out, and it's now a bill more about local control. You all have seen me that have worked with me for a number of years on a variety of different types of legislation, and a couple things I've learned. If you're working particularly on an issue that is complicated with differing perspectives, that you're either going to be at the table working it out, or you're going to be on the table being consumed. I've also learned that if it's important to solve today the things that are ripe and leave for tomorrow those that are not. This bill is a compromise that I do believe is ripe for today. What the bill does, it's in your book, is it constructs a framework for solutions between and for the City of Atlanta and Fulton County on the congestion and overall transportation challenges that they face. It does respect the differing expectations, priorities, manner, and timing of the local communities and the people that live there. So why does it matter? Well, not that I have to remind you, but Atlanta is the most traveled, has the most traveled airport. Multiple Fortune 500 corporations, our state's capital, and 5% of the state's population. The remainder of Fulton County has another 5% of the state's population, and the county directly abuts 10 counties: Carroll, Coweta, Fayette, Clayton, DeKalb, Gwinnett, Forsyth, Cherokee, Cobb, and Douglas. It does serve as a crossroad for much of the commerce and the commuters in the greater metropolitan area. It is distinct because of these characteristics, but I do want to say that I do not for 1 minute think that my county is any more significant than any of your counties. Its people and its problems are not more important. They are simply what I'm trying to address in this particular bill. The bill only pertains to Fulton County. It's 33 pages. There's probably about 80 new lines of law in the bill. Most of it is purely duplicated from what is already in current code. In the bill, Atlanta will be treated separately with regard to MARTA, and that local community, which has made that a very high priority in its local government, will be allowed to go forward, should they choose, with up to a 0.5% MARTA sales tax. That will be embedded within the cap of the T-SPLOST, mini T-SPLOST bill that was passed last year. It does not create something outside of that. It would simply consume up to half of that tax. Last year, we created 159 special districts for T-SPLOST, should counties want to do that. Now, many counties will choose not to because you have SPLOST available in your county now, which many of your counties renew periodically, and you take care of infrastructure needs. 2 counties in Georgia do not have access to SPLOST, DeKalb and Fulton. We have MARTA instead. Those counties probably will want to take advantage of that ability to have a limited 5-year T-SPLOST. This bill creates 2 distinct districts for T-SPLOST within Fulton County. One is comprised of Atlanta, and the other will be comprised of North and South Fulton. Why is this important? Important so that if or should Atlanta choose to go forward with a MARTA tax, it will not impinge on what the rest of Fulton County, which is home to about 500,000 people, can do. The Section 1, I just want to mention, pertains to MARTA. except for, gosh, pages 2 and 3, all of that is already in the MARTA Act. It is not new code. It simply had to be repeated in here to pertain to this up to 0.5% tax. Section 2 pertains to T-SPLOST for Fulton County outside of Atlanta only. The refining language that only would pertain to that area is on pages 16 and 17. In Section 3, it pertains only to that T-SPLOST district that would be in the city of Atlanta. And the refining language is on pages 25 and 26. I do ask for your support today. This has been a difficult issue to come to agreement with, but I do believe it is in the best interest of North Fulton, where I live, and our priorities, South Fulton and Atlanta, but it does honor the differences in those areas. I do think, having worked through this process over the last, 8 or 9 days, I'm certainly no expert on transportation, but I have come to see when we respect the differences, whether it's in your area where you come from or within a very large county like Fulton County, that we can solve the complicated transportation needs of those that live in a metro county or in a rural county, including those who choose to get to work by car, which is more likely up in where I live, those that prefer transit or need transit, the elderly, those with disabilities, and those just needing other types of legislation. This bill, in working with a number of different people, I'm seeking a solution with your assistance to something that has been in the way of us moving forward on other important issues as well in Fulton County. And with that, Mr. Speaker, I'll be happy to answer any questions.
Do you yield?
I certainly do.
Chair recognizes Chairman Martin to your right for a question.
My friend, the lady from North Fulton, yield for a question.
I do.
Madam, isn't it true that this just deals with the pennies that were authorized in the past and doesn't authorize any new taxes?
That is true.
Isn't it further true, if the lady would yield for another question?
I do.
Isn't it further true that while earlier this year, MARTA and our friends in the Senate tried to work a top-down solution plan for our voters, that this bill, Senate Bill 369, instead enables a ground-up solution to allow our local communities to be engaged from day one and create a plan that best works for them, whether they be in the city of Atlanta, Fulton County, DeKalb, or Clayton. This allows for more local control. Is that not true?
I'm sure the man knows of which he speaks.
Do you further yield?
I do.
Got a little interest down in Albany in this issue. Chair recognizes Representative Dukes to your left for a question.
Thank you, Mr. Speaker. And that is kind of my interest. I'm kind of trying to figure out, are you all now, we're creating another tax district? Like now we have 159. So now we're going to like have 160 because the city of Atlanta will be able to do?
Yes. With respect solely to the T-SPLOST tax, that is true.
Thank you.
And I did fail to mention that I am reducing the maximum allowable amount for T-SPLOST for North and South Fulton from 1 cent to 0.75. We're actually reducing the level of that tax.
You have another question, if you care to yield.
I'll yield for another.
Chair recognizes Representative Thomas to your left for a question.
Does the leader yield?
I do.
Is it not true that this is a good, solid bill that would help Atlanta, Fulton County, and that would help those people not only interested in transit, but those that are interested in getting out of their cars and not being stuck in congestion and traffic?
I do think this bill will allow Atlanta to choose how it wants to solve its congestion and transportation issues, both either through transit but also they will be able to also do T-SPLOST in a way that fits their needs, not necessarily those that are the priority of the rest of the county. With that, Mr. Speaker, I'm going to yield the well.
No further questions.
In just one moment, I did want to mention there's an amendment on your desk that was also part of the agreement, and I would also ask for your favorable consideration of the amendment and the bill. And with that, Mr. Speaker, I yield the well. Thank you.
Lady has yielded the well. Chair recognizes the Dean of this House, Chairman Smyrie, to speak to the bill.
Mr. Speaker and ladies and gentlemen of the House, I rise to support Senate Bill 369 as committee substitute as amended. And first thing I'd like to do, I'd like to thank the Speaker Pro Tem for her leadership on this issue. I have worked with a lot of members of this House, and I want to thank her. And I stand before you because I think this is something that is very healthy for the city of Atlanta and for MARTA. And I want to thank the chair of the committee, Chairman Maxwell, and the members of regulated industry. We met several times. I remember last year dealing with House Bill 170. And to me, House Bill 170 was an important measure and a historic one. It was a bill that I was involved with totally, and a lot of that credit goes to the members of this House and the Speaker and all of the minority and majority leaders. And that is something that we dealt with last year. One of the things that we talked about last year was transit. And to me, this is a commitment to that conversation. I remember speaking with Speaker Pro Tem Jones after House Bill 170 passed, and we talked about coming back this session doing something as it relates to transit. To me, this is a major foundation for getting that accomplished. And the fact that we are creating 2 districts for the city of Atlanta and for Fulton, and that MARTA will be able to exercise their responsibility by levying the tax and at the same time having a T-SPLOST for the Fulton and Atlanta areas. To me, this is pro-business, it's pro-jobs, it's pro-quality of life. And I want to say to MARTA, I think in a way, trust and credibility has allowed us to get where we are in this juncture, and I want to commend them for the work that they've done. And I'm asking you to join us in passing Senate Bill 369, and to pass the amendment as well. The amendment deals with the relationship of the city and the county as it relates to the governing aspect of it, because each city must submit to the governing authority of the county in which the municipality resides. And at that juncture, the issue is put on the ballot. So this is something that is long overdue, and I'm just so thrilled and so happy. Is this the full deck that I would have liked? No, it's not. But to me, this is a major, major step in the right direction. And I just come to ask if you would join us in voting in support of Senate Bill 369. And with that, Mr. Speaker, I'll be happy to answer any questions. If not, I'll be happy to yield the well.
Is there any objection to the previous? I'm sorry, you had no questions, Chairman Smyrie. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is an amendment. It is the Jones-Smyrie Amendment, AM 340735. Clerk will read the amendment.
The amendment is offered by Representative Jones, the 47th, Representative Smyrie, the 135th, AM 340735. It's printed and distributed and is on your desk.
Is there any objection to adopting the amendment, the Jones-Smyre amendment? Chair hears none, and the amendment is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 369 will vote aye. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of Senate Bill 369. The ayes are 159. The nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Well, we're going to go out with some birthday greetings here. We're going to be out a few days, and so we got some birthdays. On Friday, it'll be the birthday of Chairman Ed Setzler. Chairman Setzler. And on Friday, in Augusta, Georgia, they'll be celebrating the birthday of Chairman Barbara Sims. And on Saturday, birthday greetings to Representative Doreen Carter. Representative Carter. Chair recognizes Chairman Tankersley for an announcement.
Good afternoon. I know everybody's ready to go home, but I just wanted you to know that we have 2 more days to get your local legislation bills on the Senate consent calendar. I have a list of those of you who have a bill over there that has not gone on to the Senate calendar. If you'd like to come by my desk, I'd be happy to share whether or not you're on this list, or you can just go over there and check with your senator to make sure that it gets moved if you still want it to move. Thank you.
We will be doing page photographs at the rostrum immediately upon adjournment. I want the delegation from Savannah and Chatham County to note that we're getting you out. The sun's still shining. You got time to get to Savannah for tomorrow. Chair recognizes the Majority Leader of the House for a motion.
Mr. Speaker, I move that this House stand adjourned until Tuesday morning, March the 22nd, 2016, at 10 a.m., our 39th day.
The Majority Leader has moved that this House be adjourned until Tuesday, March 22 at 10 a.m. All those in favor of the motion will say aye. Those opposed will say no. The ayes have it. This House is adjourned until Tuesday, March 22nd at 10 a.m.